So how are you preparing for prelims? So it's good, nice. So are you practicing the questions that we keep on posting every day in our WhatsApp group?
Yes, sir.
Okay, please go through them. And they are not just questions. Every question is a concept, and you also need to read the theories associated with it. Okay, because the same question will not be repeated, but uh, similar nature of question may get repeated, because if you divide Indian polity into a number of parts, I believe if you practice around 1,000 questions, almost all subtopics would be covered. So make sure that along with practicing questions, you also read the related theories. So I believe in our sessions, we will try to cover almost around 250 questions in our this video lectures. And in our WhatsApp group, I think previous year OPSC question, there are around 170 questions. I'll make sure that all of them are finished. And so let us start with today's session. Shall I start?
Yes, sir.
Please read this question and answer it. Consider the following statements. The President shall make rules for the more convenient transaction of business of the Government of India and for the allocation among the ministers of the state business. The second option is all the executive actions of the government shall be expressed to be taken in the name of the President, in the name of the Prime Minister. Please answer this question.
Sir, only one.
Okay. All of you?
Yes, sir. Second option, sir, भूल ଅଛି.
कौन पे?
Name of the president है sir, prime minister है.
Okay. As per which article of the Constitution? Sorry. First one, the president shall make rules for Which kind of rules? For the more convenient transaction of business of the Government of India and for allocation among the ministers of the state business. Can you tell me which kind of rules the president makes? This is Government of India allocation of business rules, and Government of India transaction of business rules. Okay. Of business rules. Okay. All the executive actions of Government of India shall be expressed to be taken in the name of the President, as per Article 53. Yes. So let us read about the Union Executive and how it functions. The constituent units of the Union Executive and how, as per our Constitution, it functions. Okay. First, Union Executive. It is contained in the Part 5 of the Constitution, and the article ranges from Article 52 to 78. Okay. And Union Executive consists of President, Vice President, Prime Minister, Council of Minister, and the Attorney General of India. Can you tell me what do you understand by the post Attorney General of India?
Yes, sir. Highest law officer of India.
Okay. What else do you know about him?
Sir, he is appointed by president and his tenure is in the pleasure of president.
That is fine. What is his main function?
Give
People are
advice to such legal matters to president.
ସେ represent କରନ୍ତି sir.
represent କରନ୍ତି କାହାକୁ?
Government of India को.
Okay. So the president is the head of the Indian state. Okay.
Sir, ସେ either house ରେ present ରହିପାରନ୍ତି without voting sir.
I will explain all of them. Okay. So in the scheme of parliamentary system of government, we have the president, who is the nominal executive. We call it as de jure executive. And then we have prime minister, who is the real executive authority. We call him as a de facto executive. Okay. And so president is the head of the state, whereas prime minister is the head of the government. There is some huge. Okay. Some people are finding it difficult to join. Let me solve it first. Okay. So next, and this is the executive power of the union. And what is it written? The executive power of the union shall be vested with the president and shall be exercised by him either directly or through officers subordinated to him in accordance with the constitution. What do you understand by this term? Officers subordinated to him? Please answer. What do you understand by this term? Officers subordinate to him. There is a president, right? And he is to act as per the advice of the Council of Ministers, right? And he need to perform his duties either directly or indirectly through officers subordinate to him. What do you understand by this term? Officers subordinate to him.
All executive ହେଇପାରିବେ sir ଯେମିତି
Yes,
CAG.
yes.
Executive.
So it talks about the executive. Okay. And executive can be political as well as permanent
Bureaucrats.
executive. Permanent executive. And the permanent executive is our bureaucracy, right? Article 74. What does it tell? There shall be a council of ministers with the prime minister at its head to aid and advise the president, who shall, in the exercise of his functions, act in accordance with such advice. This term shall was included by virtue of this 42nd Amendment. So right now the discretionary power of the president is quite limited because he is bound to act as per the advice of the Council of Ministers. Before 42nd Amendment, that was this word was may. So the president enjoyed a huge discretionary power. But after this 42nd Amendment, he has to act on the according to the advice of the Council of Ministers. And one more thing, in 44th Amendment, as per the 44th Amendment, the president can send this advice for reconsideration. Whereas once it is again sent to the president, then he has to act in accordance with such advice. Okay. The question of whether the advice was tendered by the minister or the president shall not be inquired into any court. Next. So the appointment of Prime Minister. The Prime Minister shall be appointed by the President. What is the procedure of appointment of Prime Minister? And other ministers shall be appointed by the Prime Minister on the advice of the shall be appointed by the President on the advice of the Prime Minister. What is the normal procedure, normal convention followed by India?
The president is the leader of Lok Sabha.
No such specific such election procedure, sir, but major party can be.
There is no specific selection procedure. That is fine, absolutely fine. But what is the convention of a parliamentary democracy?
Majority party rules and the leader
Majority
Yes.
prime minister.
Leader of the majority party. First, the president will invite the leader of the majority party to form the government. Okay. Next. And as per the 91st Amendment, the total number of ministers, including the Prime Minister and Council of Ministers, shall not exceed 15%. Why is it done? What is the rationale behind it?
A proper representation.
Proper representation? No, not that was not the reason.
Flooring test.
Not exactly. After 1980s, or in the late 1990s, we have experienced vertical fragmentation of Indian polity. What does it mean? The ruling party had minority in the Rajya Sabha. Okay. And after 1990s, we have experienced coalition form of government. To satisfy the coalition partners, what the majority party does, it allocates a lot of ministries to them. Okay. So to limit that one, this amendment was introduced. Okay. At the time of independence, we had around 16 ministries. Right now, it is close to 55, I guess. Can anyone tell me what is the current number of ministries, departments and ministries in India? It is close to 55, I guess. Then the minister shall hold the office during the pleasure of the president. Can the president remove any minister as per his whims and fancies?
No.
Okay, why?
Sir,
Responsibility.
As long as they have majority in the Lok Sabha, they cannot be removed by the president unless the prime minister advises the president to do so. Okay. Then the council of ministers shall be collectively responsible to the House of People, that is Lok Sabha. They are not responsible to the Rajya Sabha. Okay. Next. Attorney General of India. He is the highest law officer. Law officer of India. And what should be his qualification? He should be qualified to be appointed as the judge of the Supreme Court. All of you, please go through these conditions also. What are the conditions for being appointed as the judge of the Supreme Court? Next, the okay. He has the right of audience across all courts and also in both of the houses of parliament. Okay, but he did not have the power to vote. Okay. Next, the Attorney General shall hold office during the pleasure of the President. What do you understand by this? And shall receive such remuneration as the President may determine. What do you
no
understand?
specific.
Sorry?
He may be removed by the president anytime.
Okay. What else do you understand by it?
The duration not fixed. Patronage duration has not been fixed, sir.
Okay. So let us say currently BJP government is ruling the central government. Okay.
Sir,
So, Sorry.
Sir, ଯେତେବେଳେ sir government ଯେତେବେଳେ sir ଭାଙ୍ଗି ଯାଏ ସେତେବେଳେ attorney general को post ବି sir ଆଉ ନଥାଏ।
Normally ସେମାନେ resign କରନ୍ତି because they are the appointee of the political party in power. Who is the current Attorney General of India?
Sir R Venkataraman.
R.
Sorry sir.
Venkataraman.
Sir, Venugopal, sir.
No,
Venugopal,
sir,
sir.
R.
Please answer.
Sir,
R
Venugopal.
Venkataraman. R Venkataraman. Okay. Next. The conduct of business of Government of India. All the executive actions of Government of India shall be expressed to be taken in the name of the President. This was the question that was asked, right? All executive actions of Government of India shall be expressed to be taken in the name of the President. That was there in Article 77. Okay. So the President shall make rules for more convenient transaction of business of the Government of India and for the allocation among the ministers of the state business. And accordingly, what he has done, these two rules are framed: the Government of India allocation of business rules and the Government of India transaction of business rules. So as per the allocation of business rules, the portfolios are allocated to different ministers by the President on the advice of the Prime Minister. Okay. And what about the transaction of business rules? As per this rule, the authority and responsibility and obligations of each department has been fixed. Yeah? Okay. So, our constitution provides for separation of powers between legislature, executive, and judiciary. Fine. So, can anyone tell me what is the feature of a parliamentary democracy? What is the feature of a parliamentary democracy?
Written constitution.
No, not exactly. What is the difference between a parliamentary
Executive is
democracy and a
responsible.
presidential form of government?
Executive is responsible to the Lok Sabha, parliamentary form of government.
Executive comes from the legislature and is responsible to it. Okay, that is the main theme of this parliamentary form of government. There is the collective responsibility of the Council of Ministers to Lok Sabha. As per Article 53 for Union Government and 154 for the state government, the President and governors, the executive power of the Union and state government are governed through the President and government, either directly or through officers subordinated to him. I have already explained this one. So, part 14 of our constitution that has been constituted, and it talks about the permanent civil service. Okay. The executive, it can be political and permanent, and the permanent executive is our bureaucracy, right? So, as per Article
Yes.
73 and 163 of our Constitution, the President or the Governor of the state are required to act according to the aid and advice of their Council of Ministers. Okay. And so, the Council of Ministers will aid and advise the President. And as per Article 77, 1, Section 1, all executive powers would be taken in the name of the President. Okay. So, the Council of Ministers would advise the President, and the President, through the officer subordinated to him, would exercise these powers, right? So what does he does? He frames rules. One is Government of India allocation of business rule for allocating different portfolios among the ministries and bureaucrats, and then another one is Government of India transaction of business rules, that is to mention the roles and responsibilities. Then it is the duty of the Prime Minister to furnish the information to the president. What are those? Every act of administration has to be communicated to the president. Okay. Next. So have you understood the structure of government at the union level, at the state level? I mean, how the Council of Ministers advise the president and how he executes it through the officers subordinated to him and the corresponding articles. Okay. Is it clear to all of you? Next. The power to increase the number of judges in the Supreme Court is vested with
Parliament.
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 Okay. I think we have discussed a similar nature of question in our WhatsApp group, right?
Yes, sir.
Okay. I would request all of you to go through them because the explanations given by the students are also very well written. You also need to go through them very well. So, the number of judges in the Supreme Court of the Parliament has the power to increase the number of judges of the Supreme Court of India. What kind of majority does it require?
Full majority.
Simple.
Okay. Simple majority. Fine. Will it come under Article 368?
No, sir.
Why?
No, sir.
There is certain provision in constitution which is not come from the 368.
Yes. I think in the last discussion class, I have elaborately discussed about this Article 368, their provisions and all. Right? I think those you who have attended the last session would have known. Next, what is the number of judges right now at Supreme Court?
34, one if justice and 33 another.
33 plus 1.
So,
Yes. This is the current number of judges at the Supreme Court. Okay. It is outside the scope of Article 368 and it is the power of the Parliament to increase the number of judges in the Supreme Court. It can be done by simple majority. Okay. And currently, by virtue of this amendment in 2019, the Parliament of India has increased the number of judges to 34. It is 33 plus 1 CJ. Next. Consider the following statements regarding or no confidence motion in India. Please answer.
C.
All of you, please answer.
Yes, sir.
Okay.
see,
Okay. There is no mention of no confidence motion in the Constitution of India. Definitely, this is true. Okay. Next one. A motion of no confidence motion can be introduced in the Lok Sabha only. 5. Because the Council of Ministers is collectively responsible to the House of People. That is Lok Sabha. As per article, which article says it, talks about it?
25, sir.
75, sir.
The articles that I have discussed in the previous question, please all of you go through them. Because you can put those articles in the mains answer writing. They are very much important. And the support of how many members is required for consideration of this no confidence motion? For admission of this no confidence motion?
50.
Yes, greater than 50. So, and it was not mentioned in the Constitution of India. Where was it mentioned?
Lok Sabha. Rule 198.
Rule 19.
Rules of procedure.
Yes, rules of procedure of Lok Sabha. It is mentioned there. So, Article 75 says that there shall be a Council of Ministers which is collectively responsible to the Lok Sabha. Okay. and they stay in the office as long as they enjoy the confidence of the majority of the members of the Lok Sabha. Okay. So the pleasure of president means this one, implies this one. This then for passing a no confidence motion, for admission of the motion, it requires around 50 members. Okay. And it was mentioned in Rule 198 of Rules of Procedures of Lok Sabha. Rajya Sabha cannot pass this motion because the Council of Ministers is collectively responsible to the Lok Sabha, not Rajya Sabha. Okay. So it can be introduced only in Lok Sabha. Currently, a no confidence motion has been introduced. So, what was it all about?
Sir, the opposition defeated, sir.
Manipur is
Sir, Manipur
Yes.
issue can be.
Because of the Manipur issue. Because the government has to give some statement, has to give some authoritative statements. For that statement only, they have introduced this one. Next. The Prime Minister of India at the time of his or her appointment need not necessarily be a member of the one house of the parliament, but must become a member within 6 months. Please answer this question.
B, sir.
All of you.
Sir,
A,
A have
A হবো।
Can you cite example of a prime minister who was not member of the Lok Sabha or even parliament at the time of his appointment?
Sir, Indira Gandhi, Rajiv Gandhi. Indira Gandhi, sir.
ইন্দিরা গান্ধী।
Sir, Manmohan Singh.
One.
I think it is Rajiv Gandhi. At the time of assassination of Indira Gandhi, he was not. Rajiv Gandhi was not a member of the parliament. Okay.
Yes, sir.
So suddenly he was made the prime minister of India, and at that time he was not a member. So the correct option is option A. What about this option D? Must be a member of the Lok Sabha. Whether it would be correct or not.
Either option.
Sorry, either houses. Can you cite examples of a few prime ministers who are the members of the Rajya Sabha?
মনমোহন সিং।
Rajiv Gandhi, even at some point Indira Gandhi, and definitely Manmohan Singh. So, as per Article 75, the Constitution provides that Prime Ministers shall be appointed by the President. And as per our convention, what does the Prime Minister do? What does the President do? He would appoint the leader of the majority party. Yes. Okay. The Council of Ministers has to aid and advise the President, who shall, in accordance of the Advice Act, okay, as per the 42nd Amendment Act. Next. As per the 44th Amendment Act, the President can send the advice for reconsideration, but once the advice has been reconsidered, he has to act as per the advice. The Prime Minister shall be appointed by the President, and the other ministers shall be appointed by the President on the advice of the Prime Minister. Okay. And the total number of Council of Ministers shall not exceed 15% as per the 91st Amendment Act. Next. Please answer this question. A deadlock between the Lok Sabha and Rajya Sabha calls for a joint sitting of the Parliament during the passage of which bills?
Only ordinary bills.
A only, sir.
A, sir.
One only.
A, one only.
Okay. All of you?
Yes, sir.
Okay. Yes, the correct answer is A. What about Constitutional Amendment Bill?
Sir, joint sitting हुएनी sir, ସେଥିରେ ହୁଏନି କି money bill ବି sir हुएନି.
Money bill and also not joint sitting.
constitutional bill रे either house रे pass both of the houses रे pass होगा पड़िबो, right?
Yes, sir.
Individually both of the houses रे pass होगा पड़िबो. And what about money bill?
Only Lok
Rajya
Sabha.
Sabha and recommended.
Only Lok.
Only Lok Sabha रे introduce करा होगा, right? And what is the role of Rajya Sabha in case of money bill?
Recommended in nature, sir.
Okay. And what if the Lok Sabha doesn't accept the recommendation?
It will approve, sir. Lok Sabha will pass the bill, sir.
Okay.
Without affecting it, sir.
Which article of the Constitution deals with the money bill?
110. 110. Sir, 12.
And which article of our Constitution deals with the budget? That is annual financial statement.
112, sir. 115.
112.
So let us discuss about it. Okay. So in which cases the joint sitting can be called upon? First, if the bill, it can be called upon only in case of an ordinary bill. Okay. If a bill is rejected by the other house, if the house that have finally disagreed to the amendment to be made, let us say Lok Sabha has passed the bill and it was transmitted to the Rajya Sabha, and Rajya Sabha has made certain amendments which is not acceptable to the Lok Sabha. At that case, we can call for a joint sitting. And if more than 6 months have elapsed from the date of receipt of the bill by the other house without the bill being passed by it, these are the reasons. Okay. Remember this one, financial bills. Okay. Joint sitting can be made for it. Okay. Financial bill 1 and financial bill 2. Okay. Ordinary bills and financial bills, but not in case of money bills or constitutional amendment bills. In case of money bill, the Lok Sabha has overriding powers. Okay. So it would be introduced in the Lok Sabha, and after that it would be transmitted to the Rajya Sabha, and irrespective of the recommendation of Rajya Sabha, the bill can be passed. And then whereas a constitutional amendment bill, it has to be passed by either house separately. Remember this one also. If a bill has already been lapsed due to dissolution of Lok Sabha, no joint sitting can be summoned. Next. So let us say Lok Sabha has passed a bill and it was referred to the Rajya Sabha, and there was certain deadlock because of certain amendments, and in the meantime, let us say the Lok Sabha dissolves and the president has recommended a joint sitting. In that case, a joint sitting can be held. Okay. बुझिहला केटा कि लोक सभा गोटे बिल लेट से पास कर साची सेटा राज्य सभा रे लेट से किछि डिसएग्रीमेंट हला और प्रेसिडेंट नोटिफाई कर देल कि जॉइंट सिटिंग करा जिवो. ओके. एट दैट केस यदि सेठी लोक सभा डिसोल्यूशन होची, so after the formation of Lok Sabha, joint sitting can be held. So who will preside over the joint sitting? This is the Speaker of Lok Sabha. Okay.
Speaker.
And it is a very exceptional provision. Till now, only 3 acts have been passed by the joint sitting of the two houses. Okay. Next question. What will you follow if a money bill is substantially amended by the Rajya Sabha?
Sir, A ହେବ.
A, sir.
A ହେବ.
A.
All of you, please answer. This is a very simple question. Because the Lok Sabha has overriding power with respect to money bill. So, the Lok Sabha may still proceed with the bill, accepting or not accepting the recommendations of the Rajya Sabha. Let us read about it further. So, the money bill can only be introduced in the Lok Sabha, that too on the recommendation of the President. Okay. Remember this one. And it can only be introduced by a minister. So, it would be a public bill, right? What do you understand by a private bill?
Sir, ସେଥିରେ minister sir ତାଙ୍କର ହାତ ନଥାଏ ମାନେ only private.
Okay. So the Rajya Sabha has restricted powers with regard to money bills. It cannot reject or amend the money bill. It can only make recommendation, and the Lok Sabha can either accept or reject the recommendations. And even if it doesn't, and if the Rajya Sabha doesn't return the Lok Sabha within 15 days, that would be automatically accepted by the Lok Sabha. Okay. Next, that would be automatically passed. Would be considered to be passed. Next. So if the Rajya Sabha doesn't return the bill within 14 days, the bill is deemed to be passed by both the houses. And when it is presented to the president can either give his assent to the bill or withhold his assent to the bill, but cannot return for reconsideration because it was introduced with his prior recommendation. Next. When the annual union budget is not passed by the Lok Sabha, what would happen in case of its rejection? If a union budget is not passed, what would happen?
D ହବ.
D. The Prime Minister submits the resistance.
Yes, as most of you have answered, the answer would be D. The Prime Minister has to submit the resignation of the Council of Ministers because this union budget, it is passed in the Lok Sabha. Okay, it is introduced in the Lok Sabha. So if it is not passed, what does it mean? The government of the day doesn't have the confidence of the Lok Sabha, doesn't have the majority in the Lok Sabha. So the lack of confidence would mean that they have lost the majority. So they have to submit the resignation. Okay. It would tantamount to a no confidence motion if the budget is not passed. Next. The authorization for withdrawal of funds from the Consolidated Fund of India must come from
B, sir, Parliament of India.
B, sir.
Okay, very good. This is a fairly simple question. But apart from the answer, we also need to read details about it. Definitely, the answer is B, the Parliament of India. So, the Constitution of India provides three kinds of funds. One is Consolidated Fund of India, one is Public Account of India, and another one is Contingency Fund of India. Can anyone tell me about this Public Account of India?
sir.
Sorry.
ତାର composition କହିବ କି sir function?
Public accounts of India. What kind of transactions are there? And do we need any kind of approval from the Parliament for withdrawal of money from Public Account of India?
Executive, sir, action.
Yes, executive action is required, and it normally covers the banking transactions, provident funds, small saving deposits, and all. Okay. We did not require any approval of the consolidated fund, approval of the Parliament. What about the consolidated contingency fund of India?
Sir, Finance Secretary on behalf of President.
Yes. And who exercises it on behalf of President? Finance Secretary. Okay. And what is the current amount? What is which
30,000 crores, sir. 30,000 crore.
Yes. Sorry, 30,000 crores. Okay. So let us read about the Consolidated Fund of India. It is a fund to which all receipts are credited and all payments are debited. Okay. Receipts like tax returns and all. Okay. All revenues received by the Government of India, all loans raised by the Government of India by issue of treasury bills, loan, wage and means advances. All money received by the government in repayment of loan from the Consolidated Fund of India. Please read all these things, this treasury bill and wage and means advances. Okay. So no money can be appropriated out of this fund except in accordance with the parliamentary law. Next. In the Parliament of India, the purpose of an adjournment motion is to
A हो
Yes, sir.
Yes,
Public
sir.
Habo.
okay. So, how many members support is required for introduction of this adjournment motion?
50 members.
Yes. Very good. So it is introduced in the Parliament to draw attention of a house to a definite matter of urgent public importance. यदि किसी urgent public importance किसी matter रहिला सेही केस रे adjournment motion introduce कराबा and it requires support of 50 members to be admitted. It interrupts the normal business of the house and it is regarded as an extraordinary device. As it is an element of censure against the government, so Rajya Sabha is not permitted to make use of this device. So adjournment motion can only be introduced in Lok Sabha. This is the main point. It should raise a matter which is definite, factual, and urgent public importance, and it can only be introduced in Lok Sabha. Next. Please answer this question.
Sir, none. D हो
Why? Please explain.
D.
Yes, sir. D.
सर ऑप्शन 3 तो रॉन्ग अछि जेहेतु पार्लियामेंट रे लोकसभा राज्यसभा प्रेसिडेंट ऑप्शन 2 also wrong because
So what would
election
be the correct? What would be the correct answer for option 2?
election dispute रे सर
Supreme Court sir decide करियो dispute.
Of which election?
President right?
Supreme Court को election रे decide करियो?
सर जनरल इलेक्शन
ना. Supreme Court decide करियो vice president और president करो, हल्ला. Right. What about a member for legislative assembly? Who will decide over it?
High Court.
Do you know the facts or it's just intelligent? It's just an intelligent guess.
सर आपण कहि सर
So definitely first one. MLA, it will be High Court. I will mention the provisions. Okay. Union territories are definitely represented in the Rajya Sabha in case of Delhi and Puducherry. Okay. They are represented in the Rajya Sabha. It is within the purview of the election commissioner, chief election commissioner, to adjudicate election disputes. No. It will be done by the High Court and the appeal can be transmitted to the Supreme Court. And as per the Constitution of India, Parliament consists of Lok Sabha, Rajya Sabha and President. Okay. So let's discuss about it. As per Part 6 of the Representation of the People's Act, it is the High Court who can look after the electoral disputes. Okay. And if the party is still aggrieved, he can approach to the Supreme Court. Okay. So remember this one. Parliament consists of Lok Sabha, Rajya Sabha and President. Fairly simple. Union Territory of Delhi and Puducherry, they are represented in the Rajya Sabha. Article 324, that is the power of superintendence, direction and control of the election to the Parliament, State Legislature, Office of the President of India and Office of the Vice President of India shall be vested with the Election Commission. Okay. What about local self-governments? What about the Panchayat Raj institution?
State
Who
Election
conducts their
Commission.
election?
SCC here.
Yes. State Election Commission is the one who conducts election for the Panchayat Raj institutions and municipalities. And in case of any dispute with respect to the election of President of India and Vice President of India, the Supreme Court would look after it. And in all other cases, the High Court would look after it. Next. Regarding the office of the Lok Sabha Speaker, consider the following statements. Please answer.
Sir,
no,
3
no.
only.
B, sir.
कौन होगा?
Sir, B.
One
So-
right.
What about the option 1?
Sir, one
He
right.
hold- कहीं की?
Pleasure of President.
Okay. He's an elected person. How would he hold office during the pleasure of the president?
Sir, ମୁଁ governor ଭାବୁଥିଲି, sorry sir.
Okay. Next, he need not be a member of the house at the time of his or her election, but has to become a member of the house within 6 months. That is for the ministers, not for the speaker, because speaker is the leader of the house, right? Speaker is the presiding officer of the house. Okay. If he is not elected, how could he become a presiding officer? Then if he intends to resign, this is fairly simple. The option 3 is correct. So let us read more about it. The speaker is elected by the Lok Sabha from amongst its members after the first sitting. Who presides over the first sitting of Lok Sabha?
Pro tem speaker, sir.
Pro tem speaker, sir.
Yes, very good. Pro tem speaker. The speaker remains in office during the life of the Lok Sabha. However, he has to vacate his office in these following cases. If he ceases to be a member of the Lok Sabha, so being a member of the Lok Sabha is a primary, like, it has to be there. He has to be a member of the Lok Sabha. Next, if he resigns by writing to the Deputy Speaker, and if he is removed by a resolution passed by a majority of all the then members of the Lok Sabha. Okay. What is his procedure of removal? He can only be removed by a resolution passed by the Lok Sabha by special majority. That is the majority of all the then members of the House, and not by ordinary majority. Remember this one. Okay. First, it has to have a support of 50 members, and after that, it will be considered and discussed. He cannot vote in the first instance. Why was it done? Speaker कहीं की first instance से vote करिए नहीं.
Sir, equality vote को precede करिए पाएं, sir.
कौन हला?
But in case of equality vote, president votes can be in the not in first instance.
ठीक अच्छे माने से कौन भाई first instance से कहीं voting करिए नहीं. Because he has to be an impartial figure, right?
Yes, sir.
He doesn't belong to any political party. तो सी यदि impartial figure रहिबे जदि first instance से vote कर देबे ताल से impartiality ता चली जिवो. So only in case of tie he will vote. Okay. So the Speaker of Lok Sabha derives his power from 3 stuffs. That is the Constitution of India, the rules of procedure and conduct of business of Lok Sabha, and the parliamentary conventions. Okay. It talks about what? Okay. Next. He is the final interpreter of the provisions of the Constitution of India. Whether it would be correct or wrong. If I say the Speaker is the final interpreter of the provisions of the Constitution of India, whether it would be correct or not. Why?
No.
His answer.
No.
Yes, very good. Within the house. Only within the house he is the final interpreter of the provisions of the Constitution of India. Okay. And this one, he decides the question of disqualification of the members of the Lok Sabha. Okay. As per the 10th schedule, that is anti-defection law. And before this Kyoto Holohan case, it was beyond judicial review. But right now it is subjected to judicial review. I have just mentioned the important points with respect to speaker in our class. Not all. Next, with reference to Indian Parliament, which one of the following is not correct? Please answer this question. All of you. Why? Someone has answered. The answer is to be A. Can you explain? Not correct. Okay. The appropriation bill must be passed by both houses of the parliament before it can be enacted into law. Both houses of the
Sir, D.
parliament. Okay. So this is wrong because it only needs to be passed in the Lok Sabha.
So,
Because appropriation bill is a part of the budget. And does Rajya Sabha has any power with respect to this budget? And this
No, sir.
appropriation bill is a kind of money bill in which the Lok Sabha has overriding power over the Rajya Sabha. Okay. So, appropriation bill must be passed by the Lok Sabha before it can be enacted into law. All other options are correct. No money bill can be withdrawn from the Consolidated Fund of India except under the appropriation made by the Appropriation Act. This is correct. Finance bill is required for proposing new taxes. Finance bill, remember, finance bill and financial bill both are different. Finance bill is a part of the budget, right? And no
Yes,
money
sir.
bill can be introduced except with the recommendation of the president. This is correct. Appropriation bill is a money bill, and in case of money bill, Rajya Sabha has only recommendatory powers. And what do you understand by an appropriation bill? That our constitution states that no money shall be withdrawn from the Consolidated Fund of India except under appropriation made by law. Okay. So if you have to withdraw any money from the Consolidated Fund of India, you need to have authorization from the parliament. So only after an appropriation bill is passed, money out of the Consolidated Fund can be withdrawn. And what does it include? The grants voted by the Lok Sabha. What do you understand by this grant? What do you understand by the grants? Demand for grants. I think you would have heard. The demand for grants put forward by different ministries were discussed by department-related standing committees. And once their reports are being placed in the Lok Sabha, it would be voted one by one. Those are the grants. Okay. So grants, they are already voted by the Lok Sabha, and it is a part of the appropriation bill. Then the expenditure charged on the Consolidated Fund of India. What do you understand by the expenditure charged on the Consolidated Fund of India? Can you cite an example? Can you cite an example? of an expenditure which is charged on the Consolidated Fund of India? Yes, second schedule.
Second, sir.
Second schedule. What is there in second schedule?
Salary and allowance.
Of
President, Governor of State, sir. Speaker, Deputy Speaker of Lok Sabha. Chairman, Deputy Chairman of Rajya Sabha.
okay, fine. So one more thing, an amendment cannot be proposed to the appropriation bill. Okay, because you cannot modify this charge expenditure and these grants were already voted upon. Okay, so no amendment can be proposed for the appropriation bill. Okay, next. Appropriation bill becomes appropriation act after it is assented by the president, and this act authorizes payment from the Consolidated Fund of India. So let us say when is budget introduced in the Parliament, in the Lok Sabha? Can anyone tell me? What is the date?
First February, sir.
31 March.
1st February. This is the time when budget is introduced, and it will definitely take certain amount of time before it is being passed. So budget is for 1st April to 31st of March. Okay. So after 31st of March, you will not have any money to spend unless the budget is approved. What if the budget is not approved before 31st March? What would you do? What does the government do? यदि बजेट 31 मार्च पूर्व अप्रूव न हो पारला तो कौन करा हबो से केस रे बजेट इंट्रोड्यूस कराला 1st ऑफ फेब्रुअरी ओके और 31st ऑफ मार्च में हम पाकर फंड अछि based on the previous year's budget. So what can be done if the budget is not passed before this 31st of March? Next term.
Sir, excess grant ru आने हो कि sir?
Vote on account. Okay. We require a vote on account. Okay. Vote on account. So along with the budget, one vote on account is passed. Okay. And it gives around one of the estimated expenditure to the executive. तो budget pass हुआ पूर्व एतिक amount around 2 months of expenditure meet करिया पे already executive को दिया जाता है pending its approval from the parliament and president. Okay. So after 31st March we government can function with this vote on account. Next. Please answer.
हेले सर सब प्रीवियस क्वेश्चन आंसर कोन थिला सर
कोटार
वे सर
this
जोटा
question
देखैले
answer
12
तो
नंबर
बहुत easy ही थिला ना appropriation bill must be passed by both houses
सर
of the parliament.
नॉट करेक्ट पचारथिला सर
नॉट करेक्ट पचारथिला ना तो एटा खाली appropriation bill हमको लोकसभा में पास होबार अछि राइट
तो
तो एटा both
ए
houses
हबो ना सर आंसर
आंसर will be है definitely. Okay. तो हम आंसर से रिलेटेड कॉन्सेप्ट्स भी जहाँ अच्छे से उड़ा भी पढ़ी दूँ. ओके से इतने उड़ा से बासी वाला. नेक्स्ट. प्लीज आंसर दिस क्वेश्चन. प्लीज आंसर.
3 right. Sir, 3 rights.
So option such A, B, C, D. Which one will be correct? Please answer.
C, sir.
Why
Sir,
C?
1 and 3.
What is there in option 2? Unless sooner dissolved or there is an extension of the term, there is an automatic dissolution of the Lok Sabha by efflux of time at the end of the period of 5 years, even if no formal order of dissolution is issued by the President. This is correct or wrong? What is the tenure of Lok Sabha?
5 years.
5 years. And how it can be extended?
During emergency.
During emergency.
So please read it again and tell me whether it is correct or wrong. Please explain. So the term of the Lok Sabha is 5 years. So if it is not extended beyond the term, definitely it would be dissolved. Okay. Even if the order is not issued by the President. So definitely it is correct. First one, the Speaker of the Lok Sabha has the power to adjourn the House. Definitely adjourn sine die. That can be done by the Speaker. But on prorogation, it is only the President who can summon the House. What is the difference between an adjournment and prorogation? An adjournment ends the
Session, sir.
session.
The day of the
Prorogation
Or
basis
sitting.
is-
sitting, sir, sitting.
Okay. And prorogation? It
Sir,
ends the
session.
session. Okay.
Periods.
Yes. So adjournment that ends the session. Sorry, that ends the sitting, whereas the prorogation ends the session of the House. Right. So if there is a new session, then President has to summon the House. So this is definitely correct. 2 is correct. Then third, the Speaker of the Lok Sabha continues in office even after dissolution of the House until immediate before the first meeting of the House. What does happen at the first meeting of the House? A Speaker pro tem is chosen.
Pro tem speaker, sir.
Yes, pro tem Speaker is chosen and he would facilitate the election of the next Speaker. Right. So all three options are correct. The answer would be D. So Speaker is the presiding officer of the Lok Sabha. Adjournment, he is the one. This Speaker is the one who does this. Okay, and adjournment ends a sitting. Okay. Adjournment sine die. What does it mean? Termination of a sitting of a House without any definite date being fixed for the next sitting. What normally happens? The Speaker would do this adjournment sine die, and after that, the President would prorogue the session. Okay. Speaker first adjournment sine die declare कर देंगे, तापर President prorogation करेंगे. This is the difference. Adjournment, it only terminates the sitting of the House, whereas prorogation, it terminates not only the sitting but a session of the House. Adjournment is done by the presiding officer of the House, whereas prorogation is done by the President of the India. Okay. Then there is no effect on bills in case of an adjournment, whereas in case of prorogation, what does happen? Only the pending notices would be lapsed, right? But in case of Britain, it would lead to end of bills. This is not required for us. Only the pending notices would be lapsed in case of prorogation, right? I think we have already discussed about it in our WhatsApp group. I think those who have solved the question would have known. We have discussed about this, right?
Yes, sir.
So I would advise all of you to solve the questions that are given in the group, because till now I think we have covered around 100 questions. and I think till OPSC prelims you would be able to solve more than 300 questions in the group itself. So please follow it. Next, I think someone has said explain the option C. Option 2, I think. This is what the normal tenure of term of Lok Sabha is 5 years. Okay, unless it is extended by a national emergency, it would automatically be dissolved after 5 years.
Sir, flux माने कौन?
Flux of time. Contextually बुझिବାକୁ पड़िबो. Okay. यदि टाइम रो माने within the time यदि सेटा डिजॉल्व करा होनी. Okay. माने एक्सपायरेशन ऑफ टाइम जो टर्म जोडा रहउची लोकसभा रो ता भीतर जे ताको डिजॉल्व करा हो नाही. ओके, तो फिर भी after the completion of tenure it would be automatically dissolved, right? Yes, president's order is not necessary. Please answer this question. Which of the following statement is not correct? Please answer. In Lok Sabha, a no confidence motion has to set out the grounds on which it is based, whether it is correct or not. Do we need a ground?
No, sir.
Okay, so we do not need a ground. Next, in case of a no confidence motion in Lok Sabha, no condition of admissibility had been laid down in the rules. There is no condition, right?
Yes, sir.
We just need support of 50 members. That's it. And once it is admitted, it has to be taken up within 10 days of the leave being granted. Okay, this is also correct. And Rajeshwar is not empowered to entertain the motion of no confidence because the Council of Ministers is collectively responsible to the Lok Sabha, right? So in case of no confidence motion, there is no need to set out the grounds on which it is based. It would require support of at least 50 members, and Rule 198 of Lok Sabha specifies the procedure for motion of no confidence. Okay. Next. In India, judicial review implies what? What does it imply?
Yes.
Okay. Would you please explain? What do you understand by the term judicial review? And do you even need it?
Yes, sir.
Okay. What do you understand by the term judicial review?
सर जो माने लोकसभा और राज्यसभा कौनसी भी लॉ जदि से माने किछि भी फॉल देखा गला ताले से सुप्रीम कोर्ट किंबा हाई कोर्ट ता ऊपर एक्शन नि पायो माने
Only for laws. Is it
judgment
only
paper.
restricted to legislative actions?
Executive action भी होगा.
Okay. In our democracy, we have separation of power between the judiciary, executive, and the legislature. Okay.
Yes, sir. Yes, sir.
So the judicial review implies that the judiciary is getting involved into the domains of legislature and executive. Does it imply so?
Yes, sir.
then this is against the principle of separation of power. Okay. In parliamentary form of democracy, we do not have any rigid separation of powers. In our case, the legislature comes from the executive and is responsible to it. Okay. And judiciary, what it does, it looks after the constitutionality of the actions of legislature and executive. It is the custodian of our constitution. It makes sure that the legislative and the executive actions are done as per the provisions of the constitution. And if it is not done, then to protect the rights of the citizen, it would intervene. It would intervene into the domains of legislature and executive. Okay. And when was it become prominent, this judicial review? Judicial review Indian context केबे actually start हला? यदि executive और legislature तांको domain रे यदि fully function करूछंती, fully भलो से वह काम करूछंती, then why do you even need a judicial activism? Because there, in 1980s, there was a political vacuum at the center. Okay. There is a vacuum in the executive. Okay. And people were aggrieved. They wanted solutions to the problems faced by them. So they have approached the judiciary. And that was the time when the vacuum left by this executive and legislature was filled upon by the judiciary. Because judiciary had intervened to protect the rights of the citizen and to protect the Constitution of India. That was a brief history of judicial activism. So let us discuss more about it. So, judicial review means the power of Supreme Court and High Court to examine the constitutionality of any law. Okay. So definitely, as most of you have answered, the option A would be correct. Okay. Next, the judicial review is defined as the doctrine under which the executive and legislative actions are reviewed by the judiciary. Okay. Remember this definition. You need to write it while writing answers for main. Okay. Even though we have concept of principle of separation of powers, because we have checks and balances at place. Okay, executive comes from the legislature. We do not have any rigid separation of power. We have executive that comes from the legislature. Okay, so definitely legislature has control over the executive, like passing of budget, no confidence motion, adjournment motion, all those things. Okay, by those means, the legislature can exercise control over the executive. Similarly, there is judiciary, who ensures that our executive is run as per the provisions of our constitution. Okay, so judicial review is considered as the basic structure of the constitution, and by virtue of this case, Indira Gandhi versus Rajnarayan case. You need to remember this. This is the power of the courts to consider the constitutionality of act of the organs of the government and declare it unconstitutional if it violates the basic principle of the constitution. Can you cite an example? If a law is unconstitutional, sorry.
Basic principle of basic features.
Structure of
Sir, Kesavanand Bharati
Yes,
case
very
is sir.
good. This NJSC Act.
but
I was about to say this one. NJSC Act. This was an act where the Supreme Court has made it unconstitutional, saying that it is against the principle of separation of power. By virtue of this act, the executive would control the domains of the judiciary. Okay. So it was against the principle of the constitution, so they have nullified it. The power of the legislature to make laws is not absolute, and that the validity or unconstitutionality of such law are subjected to review by the courts. Okay. So power of the legislature to make laws is subjected to judicial review. It is subjected to the limitations imposed by our constitution. Our parliament is not sovereign, unlike Britain. In case of UK, their parliament is sovereign, right? But in our case, our parliament is not sovereign. In our case, our citizens are sovereign. Next. suo motu cases and public interest litigation. Can you tell me what is suo motu cases and public interest litigation with the discontinuation of the principle of locus standi have allowed the judiciary to intervene in many public issues even when there is no complaint from the aggrieved party? Can you tell me suo motu, what do you understand by suo motu? Okay, by itself, yes, the judiciary by itself can take up a case. Can you cite an example? While writing answer about judicial review, make sure that you write
PM
example. Sorry,
sir, PM Bhagwati case, sir, Bhodakula, sir. PIL.
PM Bhagwati, that is related to PIL. Okay, that is not related to suo motu case. He has done this one. He has discontinued the principle of locus standi. What do you understand by the principle of locus standi? It means that the party which aggrieved, only that party can approach the court and not the others. Okay. So apart from the aggrieved party, other people can also approach the court. Only aggrieved person can apply. That is the principle of locus standi. And Supreme Court has discontinued it. Okay. That Justice B.N. Bhagwati we are talking about, he was the one who had discontinued this principle of locus standi. Okay. One school girl has sent him a letter in a postcard, and she has talked about the pathetic conditions of her school. And this Justice B.N. Bhagwati, he has done? He has converted that postcard into a PIL. And from then onwards, we are following this discontinuation of the principle of locus standi. Next. The constitutional provisions. While writing answers about judicial review, make sure that you mention the articles of the constitutions which are related to the doctrine of judicial review. Okay. So the constitution, there is no direct and express provision in our constitution regarding judicial review. Okay. But the constitution has imposed definite limitations on each of the organs of the state, that is legislature, executive and judiciary. Yes, Delhi pollution by Supreme Court. That was a suo motu case. Very good. The Supreme Court has restricted the engine capacity of vehicles which can be registered in Delhi. The court is entrusted with the task of deciding whether any constitutional limitations has been transgressed or not. Because we are following constitutionalism. What is the doctrine of constitutionalism? It is limited government. Right? Odd even formula that was introduced by the Delhi government itself. I think Supreme Court has nothing to do with it. Next. So let us discuss about the articles. Article 372. It was the pre-constitution legislation, judicial review. This is not that important. Article 13, that is very important because any provision which violates the fundamental right shall be void. This is very important. Then Article 32 and 226. In 32, we have 6 writs, habeas corpus, mandamus and all. And by virtue of Article 226, High Court can issue writs, those 6 writs and other legal writs also. Okay. So High Court and Supreme Courts are the guarantor and protector of the fundamental rights. This one. Okay. So Article 251 and 254, they state that inconsistency between union and state laws, the state laws be void. Article 246, Section 3, it ensures that state legislatures executive power on matters pertaining to state list. Okay. Article 245, the powers of the parliament and state legislature are subjected to the provisions of the constitution. This is the limitation upon the power of the state and the central government. Article 136, that is special leave to appeal by the Supreme Court. Can anyone explain what do you understand by a special leave petition? What do you understand by the special leave petition? By virtue of this special leave petition, the Supreme Court can take over any matter that is pending in any court, or they can take any matter suo motu for doing justice, for doing complete justice. So this is important. Article 13 is important. Article 32, 126 is important. While writing any answer, please quote all of them. And this Article 141, law declared by the Supreme Court to be binding on all courts. The law declared by the Supreme Court shall be binding on all courts within the territory of India. This provides legislative power to Supreme Court. The Supreme Court can formulate laws also, okay? And they can declare laws declared by the Supreme Court. The interpretation of law, whatever the Supreme Court has interpreted, that would be binding. You would have heard about Visakha guideline that was done by the Supreme Court, and this is under this Article 141. Next, enforcement of decrees and orders of the Supreme Court and order as to discovery. This one. The Supreme Court, in the exercise of its jurisdiction, may pass such decree or make such order as it necessary for doing complete justice in any cause or matter pending before it. What does it mean? It gives executive power to the Supreme Court. Okay. So, the Supreme Court can direct any department of the government or any organization to act as per the order tendered by it. Otherwise, they can issue contempt of court. So this gives executive power, this gives legislative power. In Article 137, what is it there? The power to review its own judgments. It is important, but not that important. 141, 142, and this 13, 32, 226, and 136. These are very much important. Please note it down. And while writing any answer about judicial review, just quote them. And some examples of judicial review: IT Act Section 66A, that was not struck down because it interfered with the freedom of speech. Next, NJSC Act, it was stated null and void because it violated the principle of separation of power. Next, the power of Supreme Court of India to decide disputes between the center and states falls under its very simple. Please answer.
Original jurisdiction.
That's very
See,
simple.
sir.
Okay.
Sir, ଗୋଟେ doubt ଥିଲା sir.
Sure.
Sir, what is the difference between established procedure by law and due process of law?
Okay. First, procedure established by law, right? Established by law. Okay. Second is due process of law. What do you understand by the procedure established by law? Law has established a procedure, right? The legislature, like the state legislative assembly or the union parliament, they have formulated certain laws. That is the procedure. Procedure established by law. And the law has made certain procedures, and the judiciary is bound to follow those procedures. Whether it is based on any rationality, whether it violates any human rights, the judiciary has nothing to do with it. Okay. Whether it violates the principle of natural justice, the judiciary has nothing to do with it. If a procedure established by law, if some procedure has been established by law, the judiciary would follow it, no matter what. Okay. And then the due process of law. Let us say one procedure established by law, like during Maneka Gandhi case, what happened? In Maneka Gandhi case, these terms have come into play. Okay. Enforcement authorities have confiscated her passport, and they have restricted her movement to outside India. So she approached the court and she said that her fundamental rights have been violated. So as per the procedure established by law, what the court would have said, like the procedure has been established by so and so, so you have to follow it. But the law has taken the stand of due process of law, which is based on the principle of natural justice. So the court can look into the fairness of law, of application of law. If a law is unfair, if it violates the natural principle of natural justice, the court can make it null and void. Okay, is it clear?
Yes, sir. Sir, India रे sir procedure established by law apply माने follow हुए ना?
apply होउथिला एबे ड्यू प्रोसेस लॉ भी apply होछ both depending upon the
Yes.
case. Due process of law होछ American concept, procedure established by law होछ UK ର concept. Okay, हम UK ର conventions follow करथलु ଆଉ मानेका गांधी वर्सेस यूनियन ऑफ इंडिया केसेस ठारू हमें ड्यू प्रोसेस ऑफ लॉ फॉलो करे स्टार्ट करू सेथि राइट टू लाइफ आर्टिकल 21 रो एक्सपेंशन हला सेबेठ. ओके, राइट टू लाइफ, राइट टू क्लीन एनवायरनमेंट एंड ऑल जेते सब तिक रहिला सोडा सबतिक सेठि स्टार्ट हला. ओके, राइट टू प्राइवेसी एवरीथिंग. So definitely the answer to this question is original jurisdiction, right? So what is included in the original jurisdiction of Supreme Court? That any dispute which includes center and one or more states, between center and one state, any state at one side, and some other states at the other side, and between two or more states. These are the three conditions, okay, where the Supreme Court has original jurisdiction. And what do you understand by this exclusive jurisdiction? Original and exclusive jurisdiction. Exclusive means no other court has any right over these matters. Next. With reference to Gram Nyaya Act, which of the following statement either are correct? Please answer.
Both है sir.
All of you. What is the answer? What is the answer? As per the Act, Gram Nyaya can hear only civil cases and not criminal cases. This is definitely not correct. The Gram Nyaya can also hear the criminal cases. So this is not correct. The Act allows local social activists as mediators and reconciliators. Definitely, this is correct. So the correct answer is B. So let us read more about it. Gram Nyaya is a court of judicial magistrate of first class. Remember this one. Okay. And the presiding officer is appointed by the state government in consultation with the High Court. It can try criminal cases, civil suits, claims, and disputes which are specified in the first schedule or second schedule of the Gram Nyaya Act. Forget about that. Just remember that it is applicable for criminal as well as civil suits. Okay. So the main principle is about conciliation between the parties. And Panchayat courts can also function in other names like Nyaya Panchayat, Panchayat Adalat, Gram Kachari, etc. So under this Act, District Court with consultation of District Magistrate prepares panel of social workers to act as counselors. Because the main purpose of this Gram Nyaya Act to resolve the disputes by mutual conciliation. Next. Consider the following statements.
ବ୍ରାହ୍ମଣଳୟ ଆକ୍ଟରେ ଯୋଉଟା ଫାଇନାଲ ହବ ସେଇଟା ଆଉ ମାନେ ହାଇକୋର୍ଟ କୁ ଯାଇପାରିବ ନା ସେଇଠି ଫାଇନାଲ ସେଇଟା?
I think appeal nahi. Not sure about it.
Okay.
As far I remember, there is no appeal after that. Next.
If seeks certain advice and not bound.
Okay. So definitely the answer is B. Yes, correct. Yes, correct. B. So let us read about the advisory jurisdiction of the Supreme Court. Okay. Article 143 it talks about the advisory jurisdiction of the Supreme Court. And when does it apply? When President seeks opinion about the question of law or fact of public importance which has arisen or which is likely to arise. Next, any dispute arising out of any pre-constitution treaty, agreement, covenant, engagement, sonant, or any similar instruments like instrument of accession, though you would come under it. Okay. So in case of B, the Supreme Court is bound to furnish the advice, whereas in case of A, the Supreme Court is not bound. Okay. In second case, Supreme Court must tender his advice, whereas in first case, it may tender or may refuse to give any advice. Okay. And the advice of the Supreme Court is not binding upon the President. He may follow or may not follow. The thing is that it gives an authoritative legal opinion on matters decided by it. That is the thing. Is it clear? Next. Consider the following statements about right to property.
B, sir.
B, sir.
Sir, B.
What about option 1? Article 301, it is about this is about freedom of trade, commerce and intercourse. Okay. Right to property is a legal right but not a fundamental right. It was a fundamental right and by virtue of 44th Amendment to Constitution, it was abolished. Yes, as you have mentioned, 44th Constitutional Amendment has introduced this Article 300A. Okay. Next. Article 301, it is about freedom of trade, commerce and intercourse. Subject to other provisions, trade, commerce and intercourse throughout the territory of India shall be free. Okay. And in original Constitution, right to property was a fundamental right. It was abolished in 44th Constitutional Amendment Act, which has introduced this Article 300A. Next. This is the last question of the session. In India, the separation of judiciary from the executive is enjoined by. Very simple question.
B, sir.
Sir, B.
B.
Very simple.
DPSP.
Yes, APSP. Which article?
51, sir.
Article 50, sir.
Yes.
50.
Yes. Article 50. Okay. So with this, we are done with our today's session.
Thank you, sir.
Our coming sessions, I also solved few questions. I think till now, I have solved close to 100 questions in our discussion classes, right?
Yes, sir.
Okay. So I would request all of you to please go through them, and I will share all these PDFs in those in the description section of those videos. Okay. I'll share all these PDFs and please go through them before you appear the OPSC prelims, because I have put the selective points. You do not have to read Lakshman from cover to cover. You just go through them. Okay. And before prelims, I'm targeting to solve close to 250 questions in our discussion classes. Till now, I have solved around 100, and I'll solve another 150. And in our WhatsApp group, we'll solve close to 300 questions. I think that would suffice. If someone religiously follows them, then I believe you would be able to solve almost all questions in OPSC prelims. Because in OPSC prelims, most of the questions are of basic nature. But the thing is that you need to cover all those concepts. And you need to make sure that you solve, like make all questions correct in polity. Because there are certain areas where questions are unpredictable, like ancient and medieval history, like the current affairs and all. So make sure that you solve these questions first, like the questions from in modern Indian history, the questions from Indian polity, basic science, and India and world physical geography. Make sure that you first complete all these parts, and after that you can go through the other parts, because these portions will fetch you solid marks. So any other doubts or anything you need? Again, please, which subject